and Human Services, it's the Department of Justice, and oh yes, our friends the states. You can make a pretty good argument that the state of California deserves a place side by side with the national government institutions in international discussions about privacy because its influence is so powerful. Second, there's a huge interdisciplinary dimension that means that within a single area of policymaking, individual agencies find it necessary to cross borders. If you're going to talk about the IP competition interface, you must be involved, for example, with the Patent and Trademark Office. So it's not just the fragmentation within one discipline, you're crossing property boundaries to deal with others. Third, we've talked about the increasing cross-border spillovers that are so obvious in this field, decisions by individual jurisdictions, linked to effects in other jurisdictions. There's a huge amount of interdependency, and many jurisdictions, because they are powerful enough, have the ability through their unilateral steps to impose, in effect, broad-based standards. Now, to a certain extent, as Edith mentioned, there's a bit of ignorance out there, but there's something else going on. There's a real contest for who sets the standards. There are rival standard-setting agencies. I discovered in the mid-part of the previous decade going to give talks in Europe where they would begin by saying, now we will hear for the Anglo-Saxon representative. That's an epithet, by the way, on the continent, about the ridiculous privacy regime in the US. So the Anglo-Saxon delegate. By the way, there's another hyphenated vulgar expression that is the translation of that. The Anglo-Saxon delegate gives the talk. I had a slide that said, here's the statutory framework, looked a bit like that. And here are the top 10 cases in the last 5 years with the recoveries. Have you guys got anything like that? Of course not. I thought, fine, the point's across. Next year, same criticism, same slide. What I discovered is that they want to believe that. That is, especially in Europe, there is a sense of wanting that standard to prevail. So it is not just a matter of not knowing enough about the US regime. They know quite well, in the way that a taxi driver in Paris, as you try to speak your best French, says, "Oh, monsieur, I do not understand." Understands quite well, but is not going to converse with you in French. In this instance, they know what the US framework is, but there is a desire to have the European standard applied broadly. Another circumstance that makes it difficult is we talk about civil society, extraordinary fragmentation. If we just look in the privacy domain, if we look at advocacy groups that have had a role to play in this, a very diverse array of views about how stringent in what areas privacy policy should be developed over time, it's extraordinarily difficult to get